Right. Good morning, everybody. Welcome to our virtual webinar. If I could just introduce the various panelists first. So firstly, our guest is Siobhan Leyden, who's the Director of the Retail Association. Then on the top right of my screen, I'm not sure on yours, is Talita Loubser. Talita is an employment and benefits partner in our Joburg practice. She's been very involved with Business for South Africa in all of the representations around the COVID and lockdown. Then Randall van Voor is a partner in our Cape Town practice, and he's joined together with Mendel Sass, both of them in the employment and benefits practice. So at this point in time, we seem to have a virtual firm, and it doesn't seem to matter where you work, whether it be in Cape Town or Johannesburg. Just a couple of housekeeping issues. Your chat function, you're all muted, so you're unable to ask questions. The chat function is disabled. If you do want to ask questions, use the Q&A button, and I'll try and pick up where questions are coming in and try and direct them to the various panelists. So you can use that button and that function. It's apparent to us that, obviously the advent of COVID and the lockdown has had a material impact on all of us. It's had an impact on the society we live in, the way we shop, the way we live, the way we do business. It's had an impact on businesses generally, and it's had clearly a very, very material impact on the retail sector. That impact is both, in our view, short-term and it's long-term. In the short term, we're all dealing with the implications of COVID, and we're learning new terminology like quarantine, vulnerable people, all of these kind of words that we've had to learn, and there's material impacts that have obviously impacted the retail industry, and we're going to have to be dealing with that. In the longer term, I think we're going to see material changes in the retail industry as well. We're going to see, and I think we're already seeing, a move to online shopping, a move away from the malls and the high streets. We're going to see much greater reliance on distribution and warehousing as we move through to online shopping. And I think all of that's going to impact the retail sector. What we are intending to do is to break this webinar into two sections. So the first section is focusing entirely on the short-term impacts and how we are managing through this period of lockdown. And then in the second webinar, we want to concentrate on the impact over the longer term of what it'll mean to move towards more online trading, what will happen if you move more towards warehousing and distribution, as it's happening in many instances. So what I'm going to do is ask Siobhan, please, just to give us an indication of the challenges facing the retail industry at this point in time. And then after Siobhan, I'm going to ask the panelists various specific questions pertaining to the impact. But Siobhan, over to you. If you could just talk us through how the retail industry is being impacted.
Thanks, Graham, and good morning to all of the participants. I've identified 9 broad areas that I'd like to cover today, and then you will see later on in the webinar that my colleagues who are lawyers will provide advice in reference to some of these issues. But as a starting point, the most difficult one of the biggest issues that we've experienced as retailers from the start of the lockdown. So bearing in mind that the food retailers were open from day 1 of the lockdown, and clothing retailers only joined a couple of weeks later. But from the very start is the issue of inconsistent application of the regulations, the directives, and the guidelines. And when I say the inconsistent application, I mean inconsistent application by our authorities. So with retailers, obviously all members of public have access to retailers, which means you also have members or officials from the government who have free access into retailers. And what we found, particularly at the start of the lockdown, was that the food retailers were being subjected to inspections by the Department of Employment and Labour, the SAPS, the Department of Health officials, as well as municipal officials at local level. And from each of those government institutions, we were seeing a different or an inconsistent application of the law. And this created great confusion and frustration for the retail sector. Through the B4SA platform, the labour work stream, we constantly raised this through the NEDLAC structures as well as the structures where we engaged with government directly. And although there's been a huge improvement from April, we still are seeing some government officials applying the law inconsistently. The second issue I'd like to deal with is the inspection statistics that have been shared with us by the Department of Employment and Labour. The Chief Inspector last week at a NEDLAC meeting shared with social partners the inspections conducted, and I refer only to the Department of Employment and Labour inspections. And what we saw there was that since the start of lockdown, so I think it was the 27th of March, up to and including the 3rd of July, they haven't yet made available the most recent statistics, so we've got up to and including the 3rd of July. The Department of Employment and Labour had conducted 3,710 inspections. That's throughout the nation. Of the 3,710 inspections, 2,537 inspections were conducted in the retail sector. So you can see it's a high percentage of those inspections are in our sector. The next highest number of inspections done is in the manufacturing sector, where there are 278 inspections as at 3rd of July. And if I go back to the inspections in the retail sector, of the 2,537 inspections in our sector, 1,437 retailers were found to be compliant. 1,100 were found to be non-compliant. And out of those 1,100 that were non-compliant, the inspectors issued 181 prohibition notices, 251 improvement notices, and 888 contravention notices. At NEDLAC, when these statistics were presented to us, it was made very clear that a significant number of inspections in the retail sector is simply because our sector has to an extent been open from day one of the lockdown. The compliance issues that have been identified in our sector, the first one is the hand sanitizers. So the Department of Labour, each time we have a meeting at NEDLAC as the Health and Safety Subcommittee, complain that employers are not providing hand sanitizer that's at least 70% alcohol. So that's the one issue that repeatedly comes up at NEDLAC. The second issue that has come up, not at NEDLAC, we've certainly raised it, is that inspectors are issuing compliance notices to retailers for not temperature scanning members of the public who enter stores. There's absolutely no legal requirement in the Health and Safety Directive, the latest one being the 4th of June version, that says that an employer must do temperature scanning of members of the public. What the directive does say, and I'm going to read it, it says, if appropriate, undertake symptom screening measures of persons other than its employees entering the workplace, with due regard to available technology and any guidelines issued by the Department of Health. Some inspectors have interpreted this to mean that retailers are required to do temperature scanning of members of the public, and that is not correct. We've engaged with both the Department of Health and the Department of Employment and Labour on 2 occasions now in the last 10 days, and we've received confirmation from both departments that it is not a legal requirement to temperature scan a member of the public. The representatives from the Department of Health, many of them being academics and occupational medical practitioners who sit on the NEDLAC structures representing the Department of Health, have made it very clear that temperature scanning is not a reliable tool to use in identifying COVID-19. And the reason being is that unless an employer or an owner of a premises has purchased a reliable thermometer that is calibrated and is used by trained officials, you have an unintended consequence of overscreening or underscreening. And what they mean by that is if your thermometer is not giving accurate readings, you then may send some of your customers into a panic, either if it's too low or too high, and then they rush off to go and get tested for COVID. And the Department of Health don't want that, because our capacity for testing in South Africa is already under significant strain. So although the directive does not make it a legal requirement for an employer to do this, some retailers, all of us go and do our shopping, would have seen, we would have all seen that some retailers have decided to do the temperature scanning of customers, and that's within their prerogative to do so. And I'm sure that they've decided to do that based on their risk assessment. But if you do have an inspector who arrives and does an inspection and issues you with a compliance notice for not having temperature scanning at the front door of your store, you are entitled to challenge it. The chief inspector, Mr. Tabor Sazana, confirmed at a meeting last week that he has issued a written instruction to all of his inspectors to inform them that this is not a legal requirement that they can enforce. The other issue that we have found, and it's still ongoing, is the issue of decontamination or deep cleaning your premises if there is a COVID-19 positive case at the workplace. And what happened here, I think, is that in the first 3 weeks, I think it was the first 3 weeks of lockdown, we didn't have a health and safety directive. So the workplaces that were open at the time were operating under whatever the Department of Labour inspectors were telling them to do. And there seemed to be a practice that developed in the first 3 or 4 weeks of lockdown, that where a COVID-19 case was identified at the workplace, the inspectors would say to the employer, shut your entire workplace down, get an external company to come and do a deep clean, get a certificate from that company to say that they've done the deep clean or the decontamination, email us that certificate, and once we've received the certificate, we will then confirm that you can reopen. That is not required in law. All that is required in law is that if there is a COVID-19 positive case at the workplace, is for the employer to determine, and you can refer to paragraph 20.11.3 of the Health and Safety Direction, that says that the employer must determine the need to temporarily close the affected work area. It doesn't say close the workplace, for decontamination using an incident-based risk assessment with due regard to the Department of Health guidelines. So number one, there's no legal requirement that you've got to close the whole workplace. You've got to do an assessment to determine whether you should temporarily close the affected work area, and then you've got to decontaminate. Decontaminate or deep clean does not mean getting an external service provider. According to the Department of Health, officials that we engage with at NEDLAC, it is sufficient for employers to simply use a JIC solution to clean or decontaminate the infected work area. And if you can do that in one afternoon, then you close for that afternoon and you can reopen. The other issue that has come up a lot with the compliance notices, and this has been mentioned by the Department of Employment and Labour at NEDLAC, are the risk assessments. So all employers had to do COVID-19 specific risk assessments and have those available at their workplaces. The department's not happy with the manner in which these risk assessments are being conducted. So B4SA has previously sent out guidelines or documents that almost give an example of how to conduct a risk assessment, but it's important that your risk assessments are in the correct format and deal with the correct issues. Otherwise, the Department of Employment and Labour are going to issue compliance notices. So the next matter is, as I said, we've got the latest Health and Safety Directive, which is the 4th of June 2020. And most of you would have seen on Friday evening, the Department or the Minister of Health made an official announcement to say that they are going to reduce the isolation periods from 14 days to 10 days in certain circumstances. So on the back of that, we have been told that the 4th of June 2020 Health and Safety Directive will be amended shortly. The amendments will be tabled at NEDLAC for engagement. They have not yet been shared with us, but we've been told in a high-level summary that the amendments will relate to the isolation, which I've just mentioned. They are busy considering whether they need to flesh out the requirements on ventilation further, given the developments on the airborne signs that they've now released. And then they are also going to add into the directive a requirement which currently appears in the main COCTA regulations, so the main disaster management regulations, that employers who employ more than 500 employees will be required to report certain information to the DG of the Department of Health. And the information is going to be symptom screening and COVID-19 cases. And we are waiting. I had hoped that by today we would have heard from the Department of Health as to when it's going to formally announce how the system will work. It's an online system, but we have not yet received that communication. It should be any day now. But what retailers will need to start preparing for is that they're going to have someone within their organizations to complete this online reporting. We don't yet know the frequency of the reporting, whether it's daily, weekly, or monthly, but someone's going to have to input this information on the online system and submit it to the Department of Health. So we will see that amendment coming through shortly. On collective bargaining issues, we've had an array of demands from the unions, both at workplace level as well as at NEDLAC level. So at workplace level, we've had unions say, not only in retail, but in several of the sectors, say that we want to be paid danger pay because we are now required to work when there's a global pandemic. COSATU at NEDLAC are very unhappy with the retailers at the moment. On a weekly basis, they are demanding that all retailers, and this is both for food retailers as well as clothing retailers, employ more cashiers so that there are no queues in the stores. They are alleging, without any evidence, that the queues in most of the stores in South Africa are very long and that retailers are compromising social distancing. On the issue of our economic state at the moment in retailers, again, the unions think because some of the retailers have been open from day one of the lockdown that we are all doing very well. This is not the reality. I think that we will all agree on this call that in some form or manner, I'm sure that most retailers are considering or looking at their structures and at the number of employees that they employ. Although some retailers have been open from day one of the lockdown, a lot of South Africans have not been earning money during the lockdown, or if they have been earning a salary, it's been at a reduced salary. So they're not spending as much. We've got a lot of retailers that are located in tourism areas where there's no foot traffic at the moment. So their sales have decreased. We've also seen, as Graham said, an increase in online shopping. So you don't have as many people enter your brick and mortar stores to do shopping. So the need for a significant number of store employees may have decreased. So I think what is a reality is that retrenchments could potentially become something that all retailers need to consider during the course of this year, and that for the unions to say that we are all doing very well is far from the truth. Then my least favorite topic is the COVID-19 TERS Uif benefits. So Talita will deal with this in more detail, but the B4SA team have, and I'm not exaggerating when I say it, probably almost every single day since the start of lockdown. I think I've lost count now, but I think we're like on 120 something days of lockdown. We have been engaging with UIF to try and resolve the issues associated with claiming these benefits. And there are several issues. I'm not going to highlight them at this point in time, but I think what the big question is on all of our minds, particularly for our retailers who sell liquor, is whether, given that the TERS came to an end in June, or at the end of June, whether the Department of Employment and Labour through the UIF fund will extend the TERS for a further period of time. And then also, in addition to those employees who are prohibited by law from working, there are obviously your group of employees who are termed your vulnerable employees, who have comorbidities and or are over the age of 60, who cannot come to work if special measures cannot be implemented, and who cannot work from home simply because the job for which they've been hired for does not allow them to work from home. So there's been a call from both Labour and business to say to government there needs to be some sort of benefit funding put in place for those vulnerable employees who are required to stay at home. Another issue that comes up frequently, and I believe Talita will also touch on this, is when an employee does test positive for COVID, or if an employee has been exposed to a positive case, what leave must these employees be put on? And then you will all be familiar with the Compensation for Occupational Injuries and Diseases Act. And a couple of days before the lockdown started, if my memory serves me correct, I think it was the 23rd of March, the Compensation Fund Commissioner published in the Gazette a direction on how COIDA claims would be dealt with for employees who contracted the virus in the course and scope of their employment. That directive is going to be replaced by a new directive. It has been signed by the Minister, but it has not yet been published in the Gazette. We have followed up with the department yesterday because the new version of the directive was signed by the Minister on the 30th of June. So it's been some time since he signed it, but it has not yet been gazetted. So we asked yesterday when they intend to gazette it, but we have not yet received a response. The purpose of amending or replacing that directive is to give clearer guidance to both medical practitioners and employers as to what they need to do if an employee has contracted the virus at the workplace. And it also, given how science has developed from March, when we first went into lockdown, they've also updated the directive to take into account those developments. So I think just to flag that you keep a lookout for that, because it will be published. It should be published in the Gazette fairly soon. So I think I've now spoken for my time slot, so I'm going to hand over to Graham. Thanks very much.
Siobhan, thank you very much for that. It was an incredibly useful overview for us, so thank you. Talita, I'm just going to turn to you now, if that's okay. Where are we now with these famous TERS benefits and them being extended or not extended? Where exactly do we stand?
Graham, yeah, we had a meeting on Sunday evening where the actuaries of the fund presented their estimates and projections. And in terms of those projections, they said that it is affordable for the UIF to extend the benefit by another month, and that they are proposing a flat rate benefit rather than the benefit calculated in accordance with the sliding scale, and then particularly in relation to vulnerable employees and employees of businesses that are still closed. The social partners, Labour and business, considered that presentation and the proposal, and what is being proposed is an extension for 3 months rather than only 1 month, particularly in view of the fact that so many businesses are still completely closed, or because of the requirements of the regulations need only a certain percentage of employees at their workplace through rotation and shift systems. So not all employees, even if your employer is open, are able to come back full time. Also, Labour made the proposal that it shouldn't be determined on a flat rate of 3,500 per employee, but the sliding scale formulations should remain. So on Sunday night, it took to go back and to look at the numbers, and those are actually being discussed as we speak now at 10 o'clock in the NETLAC meeting, where they are considering the extension. So hopefully we will see an extension. The directive is actually already drafted to make provision for the extension. So it is now just a matter of making sure that there are sufficient funds to do this, and to do it in the most administratively burden-less way. We've seen lots of issues with the way in which employers and employees had to apply for these TERS benefits. There's a list of outstanding queries with the UIF, and slowly but surely they are chipping away at those issues. Yeah, certainly there has been instances of fraud, and the Hawks are involved and are looking at those instances. But there are lots of allegations in the press made against employers, and how employers are not making the applications correctly, or are claiming on behalf of employees who are not affected. There are valid concerns, but there are also issues on the UIF's capacity side, and all of these things need to be worked through systematically, but we hope that we will get there. There was a press release in terms of which applications for April are set to be closed. That's not so. It's not been agreed that the applications are closed, and there's nothing in the directive that says that applications for a particular month closes on a particular date. So it's that was just an inaccurate statement. So yeah, we are hoping to get clarity on the extension of the benefit. Just on the vulnerable group employees, those are people who cannot work remotely, and in respect of whom there cannot be special measures taken to allow them to work safely. It's not all people who are vulnerable who need to be at home. If the employer can implement special measures for those employees, they can come to work, and they can come and earn their income. But it is recognized that there are certain areas, like in mining, for example, where the employer isn't able to take any additional special measure, where those people shouldn't come to work. So it's really in order to catch that group of people, in addition to those who cannot come to work because the industry is still closed.
Yeah. So what you're saying is essentially it's not an absolute that they may not come to work. It's a question of reasonable accommodation. And what do you do about paying that group if they are unable to come to work and they're unable to work remotely and you cannot take special measures? What's the question then on pay?
Yeah, from the employer's perspective, we think it is the same as with the initial lockdown, that they cannot come and tender their work due to these government regulations, and therefore it is unpaid from the employer's perspective. And this is why it is so important that the TERS benefit be extended, so that there is a safety net for these employees.
Okay. So now so let's just deal with employees then who do test positive. What are the employer's obligations in regard to that?
Okay. So there, I think there are three things that one needs to keep in mind. First, the employee that tests positive. Second, the employees with whom that individual were in contact. And third, cleaning of the premises. And the direction deals with all three of those things. So in relation to cleaning of the premises, Siobhan explained it's not necessary to do a complete shutdown. You make sure that the affected area is properly cleaned. Might be that you need to close your whole shop, but it does need to be cleaned by some special cleaning company with nano, silver, whatever solution. It can be simple jig. Now, the employee who tests positive needs to be in isolation. So that employee mustn't come to work, and that employee needs to be on sick leave. That is sick leave under the BCEA, so it is paid leave. If the employee has exhausted his sick leave, then the employee can apply for illness benefits under the Unemployment Insurance Act. The TERS directive also referenced illness benefits and made it a little bit more simple to apply for, because all you needed was a letter from the employer saying that the employee is in self-quarantine. There are symptoms, the employee is there, and certificate or a report from a medical doctor wasn't needed. That directive has lapsed, and there's nothing in any other document that makes that shorter process applicable. So if the employee has exhausted their sick leave and needs to apply for sick leave under the Unemployment Insurance Act, you will need to follow the normal processes under that act and submit all the necessary documents. So that is in relation to employees who test positive. When they recover and they are fit to come to work, they need to get a medical certificate to that effect from a doctor. What they do not need is a negative test result. So they don't need to go back and be tested again for COVID and show the employer that they tested negative. All that they need is they are now fit and healthy to work again. And then they need to wear their special masks and apply social distancing and all those other good things. So that is the employee who tests positive. The employee whom that employee was in contact with, there the answer is it depends. So if it was a low risk exposure, and that is all concerned wore their masks or their shields and their special protective equipment, the contact wasn't for more than 15 minutes, and they were at least 1.5 meters apart. That is a low risk exposure. And that employee can continue to work. But the employer must tell that employee to carefully self-assess and monitor the development of symptoms. And the employer also needs to check that that employee is not developing symptoms, in which event the employee will then take sick leave and go be tested and so on. If there was a high risk exposure, then that is where the contact was for longer than 15 minutes, in a shorter distance than the 1.5 meters, and they didn't wear the special protective equipment. Then the employee needs to be isolated and be put on sick leave as per the directive.
And T, how long must that be for? And there's a question here as to whether the close contact self-isolation period of 14 days is likely to be reduced or amended.
Yeah, that is my understanding, that will also go down to 10 days. But for currently, it is still 14 days. 14 days.
And yes. The question of pay over that period?
It is that? If that is a higher exposure, it is sick leave in terms of the directive. And if the sick leave entitlement is exhausted, then you need to apply for illness benefits under the Unemployment Insurance Act. Of course, if the employee has annual leave available, the employer may want to allow them to take that, or the employer may want to grant them a special leave, COVID leave, but that is entirely in the employer's discretion.
Thanks very much. T, anything to add on your areas of expertise at B4SA, which is areas of TERS, UIF, occupational COIDA, all of those issues, are we covered?
Graham, yeah, perhaps just in that meeting that we had, that Siobhan mentioned with the Department of Health and the Department of Labour, they stressed that there are testing protocols in place. And one must only test between day 5 and 7 of the onset of symptoms. If you test earlier after contact with someone who tested positive, then there is a risk of a false negative. So it is also an appeal from them that employees do not just go off and test themselves, because it is a wasted test. So I think it's important that, you know, we understand the testing protocols and that we stick to them. Yeah, in relation to the COIDA directive, also there's also mention of various risk levels, and the purpose of that is really to indicate what is waarskynlikheid, the likelihood of someone having contracted the illness at work. So there are various levels. There's very high risk, medium risk, low risk, and the higher your risk level, in accordance with your profession, like your nurses and doctors, the higher the likelihood that you have contracted it at work. And then just lastly, on the reporting issue, it is only if you have contracted COVID at work or in the course and scope of your employment that you should report to the Department of Labour. All cases of transmission must be reported to the Department of Health, but only if it was a workplace acquired illness should you report to the Department of Labour. There is this provision in the direction that you need to report cases to both of those departments, but they clarified to us that the one to the Department of Labour is only if it was a work-related transmission.
So there's a further question here, Tia, in terms of the documentation that would be required to support a sick leave application for someone who has come into direct contact with someone who is positive. Is there any documentation, anything required in that regard, or is it just the word of the employee that I have been in close contact?
Yeah, I think so. There's nothing prescribed in the regulations on documents that you can rely on. I would imagine that an employer would be entitled to ask for a copy of the positive test result of the person that you claim to have been in contact with and reasonable proof that you were in contact with that person. Because one can imagine a situation where employees might think that this is now a nice way to an additional arrest.
Yes,
But yeah, you know, I think that the employer is entitled to ask for those things, but there's nothing prescribed in the regulations that deal with that.
Thanks so much, T, for your input. I'm going to now turn to our collective bargaining experts. We heard mention of the financial impact that this is having on retailers. Mendel, can I just turn to you and ask you just to describe what are the options available to employers who are facing financial difficulties? You know, what can they do? Is it always a Section 189 retrenchment, or are there other alternatives that can be considered?
Thanks, Graham, and good morning, everybody. There are a couple of options or measures that are available to employers to mitigate against the negative impact of COVID-19, the lockdown, and whatever the related economic downturn might be. At the start of the lockdown, it was geared to resort to annual leave and place employees on annual leave as a way of, whilst persons couldn't work, they'd still get paid, but at least the employer's annual leave balance would be reduced, and that would kind of give a benefit later on once the lockdown had been lifted, and that's been dealt with quite at length up until now and was quite popular. The other measures are, of course, steps aimed at cutting employee costs. So that would be reducing remuneration, for example, without changing the hours of work. Many employers have asked or have an agreement with their employees that they will be paid less, 50% wage cuts, 25% wage cuts, etc. Then, of course, there's the short time option, where employees work less hours and consequently get paid less. Then there are temporary layoffs, which is where the employees stand down for a period of time without being paid for that period. And of course, the employer then saves on wages. And then lastly, unfortunately, is the option of retrenchments or dismissals due to operational requirements. So the reduction of remuneration or the implementation of short-time and temporary layoffs, retrenchments, these are things that have always been around, and they are available in the ordinary course, but of course, deploying them in these significant economically distressing times are now more likely, and we will see more of in the foreseeable future.
Options like layoff, short time, and that, can they be unilaterally imposed, and reductions in salaries? How do you achieve those?
Yeah, so the can kind of break it down firstly into, just as a starting point, two categories: the non-dismissal routes, which are the short time, the layoffs, etc. And then, of course, the retrenchments, which might be the ultimate end result. Implementing any of those constitutes a change to terms and conditions of employment. Employers have a duty and obligation to pay remuneration when the employees tender their services. So as a general proposition, and I stress that as a general proposition, and more often than not, these changes cannot be implemented unilaterally. The unilateral implementation of these changes, for example, imposing short time without an agreement and without some of the other conditions that we'll speak of soon, will more than likely have the result that a claim, a dispute is referred to the CCMA in relation to a unilateral change to terms and conditions of employment, alternatively, breach of contract claim even to the labor court. So the starting point on this first inquiry that an employer has to undertake in deciding or plotting its course on what it's going to do is to see whether there are any collective agreements or contractual provisions that allow the employers to implement short time or temporary layoffs. So for example, bargaining councils have concluded, or collective agreements have been concluded in bargaining councils that permit layoffs or short time measures where unforeseen circumstances have altered production or affected sales, etc., etc. Similarly, rare, but it is possible that individual employment contracts could contain provisions like that as well. If you don't have those mechanisms that allow you to do it, then unfortunately, again, caveated slightly, but unfortunately, the agreement of the employees will be required. Employees, of course, have a contractual right to work full-time, to tender their services for the amount of time that they've contracted to tender those services, and that may not be unilaterally reduced. One has to then try and obtain the agreement or consent of the employees to the change, to the terms and conditions of employment. Who to engage is a question that may arise. It might not be necessary to engage your entire workforce. It will depend on your operational requirements, who needs to be engaged in relation to giving that agreement. It is also important, if you do get an agreement or you do implement, for example, short time, that where employees perform the same or similar type of work, that there is at least a rational basis for any differentiation. One can't favor certain employees and allowing them to keep working their normal hours and getting full pay. And, maybe, I don't know, crude example, trade union members are placed on short time, but people doing the same work who are not trade union members are not placed on short time. So that's something to look out for. Then just on some practicalities in relation to obtaining agreement. unless your recognition agreement or collective agreement prescribes that the employer must approach the trade union first with the possibility or the proposal of a change in terms and conditions of employment, there's nothing that prevents an employer going directly to the employees with that proposal. Whatever is agreed to, of course, it would be useful to record that in writing. It doesn't have to be a formal agreement, but an email or a letter just summarizing what has been agreed will be sufficient. But it's important, of course, that would be important for the purpose of having proof of what had been agreed to in case any parties renege in the future on that. So the annual leave question has been like I said, dealt with, but the important point to make there simply is that that's the only one of the options that can really be implemented unilaterally in terms of the BCEA, where the employees don't have a choice. But all the other options that are mentioned requires the consent. Of course, an employer can adopt a high risk approach to this, particularly where they are under serious financial duress and they can't wait any longer to implement it. So an employer could decide to act in breach of the contractual obligations and implement the changes unilaterally because, for example, they couldn't go through a retrenchment process. They might have a 189 capital A on their hands and there's a 60-day consultation period. So in order to save the business, these fairly high risk options could be taken, but on balance, the consent is required. How to obtain that consent in the absence of any mechanisms? Obviously, if you go to the employees first, you'd ask them, do you agree to a short time, for example? The employees say no. What does the employer do then? Well, the first option is to commence a process in terms of Section 189, a retrenchment process, and we'll come full circle to that later. And the second alternative would be making a collective bargaining demand. And after the 30 days have elapsed, after the matter has been referred to the CCMA, the employer could institute a lockout in order to secure agreement. And of course, that would be a power play, and the power play and collective bargaining issues will address that a bit later as well. But on the lockdown itself, that is the employer can decide to go straight to that and not try and seek the agreement up front. But the lockdown, of course, the lockout will, of course, have unintended and negative intended consequences. The employer, of course, cannot use replacement labor during that time, as it's not what is commonly referred to as a defensive lockout. However, the employer is not required to pay employees during the lockout, but more often than not, particularly in non-unionized environments, the lockdown option is unlikely to be regarded as attractive or viable. But even in unionized environments, that might be the case, as well as, of course, if you lock your employees out, then there's no production, or there's no one to serve customers in the shops or sit on tills and allow customers with the purchasing of their goods. Then the second option, besides the collective bargaining approach, is the retrenchment process, and there it have to be initiated or in terms of 189 or 189 capital A, and the options that were initially or the proposals that were initially made to the employee, do you agree to go on short time? That then can be, if I could use the word, retreaded or repeated during that retrenchment process. It could be identified in a 1893 notice as one of the options that the employer is considering as an alternative to potential retrenchments. And the employer can then again kind of get a second bite at the cherry, and maybe the initiation of a retrenchment process has focused or crystallized the thoughts of the employees, and they may be more susceptible to agreeing to to that alternative as an alternative to retrenchment. But employers may also be trying to, hopefully, to weather the storm so that they have employees, a full quota of employees if the lockdown is lifted and things return to normal. Large-scale retrenchments can affect the ethos or the culture of the workplace, and an employer may think twice about doing that, and therefore may go the short time or the temporary layoff route instead of retrenchments. Then just briefly on short time and the temporary layoffs. Again, there, when selecting which employee or employee should go into short time, care should be taken to act fairly, and often LIFO is often used as the criteria to decide who should go on short time. But the short time is generally a win-win scenario for employees. On the layoff side, there's the two forms that it can take. It can either be a temporary layoff, sorry, I beg your pardon, a full temporary layoff. So for a specific period of time, 3 months, 2 months, a week, etc., or a rotational layoff where an employee might work every second day or every third day, and employees take it in turns to come to work.
Thank Mendel. There are two important, conscious of time, and so I'm going to move on to Randall, because there are two important questions I want to ask him. Randall, what we've experienced in a number of instances is employees saying that they can't come to work because it's not safe, and they refuse to come to work. What do we do in those circumstances?
Graham, the regulations referred to earlier by Siobhan, clauses 49 through to 55, provide that an employee may refuse to perform certain work. In ordinary course, barring a pandemic, an employer might well take the view that the employee is irrationally fearful, that they're just a hypochondriac, but of course these are very different times. And so what the regulation provides is a right for the employee to refuse to work if there are circumstances that have arisen, which reasonably, says the regulation, which reasonable justification appear to the employee or their health and safety rep to pose to the employee a threat of an imminent and serious threat, rather, of contracting COVID-19. And so there is a right to refuse to work. And then it becomes quite tricky, because the workplace is a complex environment invariably. It's a large environment, typically in retail. There may be workers in a depot versus employees who service customers on the front line. And what's then required of the employer, after consultation, say the regulations, with the Health and Safety Committee and a compliance officer, the employer must then take steps to resolve the issue. And of course, that does presuppose that there is in the workplace a compliance officer who has been appointed, which the regulations do require, and that there is a Health and Safety Committee that has been established. And then there must be an attempt, an endeavoring to resolve. Allied to that, an employee who has reasonably refused may then not be subjected to prejudice, whether in the form of, for example, dismissal, the most severe form, whether in the form of harassment, whether in other less severe forms short of dismissal, such as taking disciplinary action. If that does happen, the employee then may refer a dispute to the CCMA to then by an arbitrator.
And I assume if you've brought in all your committees and your compliance people, and you're satisfied that you are doing everything to make it safe, and the employee continues to refuse, I presume then that's an unreasonable refusal, and you'd go your ordinary disciplinary route.
Quite right. After consultation with the appropriate persons, a retailer would then meet during the process of that consultation also with the employee to say, these are the steps we've taken, they're appropriate PPEs for your particular work area. We're satisfied that you haven't been in contact, direct contact, more than 15 minutes with anybody who has indeed contracted COVID-19. We're satisfied that not only is there low risk, but there is a virtual negligible risk of you being exposed to the risk of contracting COVID-19. And these are the facts on which we base that assessment, and you're required to continue working, or if the person has already emailed or SMS'd or WhatsApped from home, you're required to immediately tender your services upon the commencement of your next shift. Should the person still persist, then of course they've placed themselves in harm's way.
Thank you. So can I then just turn to the next topic, and that is that what we're experiencing as well, and we've had it in a number of places, is where the unions come along and they say, we demand danger pay or additional, some sort of premium because they are being required to work while other people aren't being required to work. How do you deal with those demands for danger pay or excess pay?
From a collective bargaining perspective, and someone interested in collective bargaining, it is an exciting time. It's very complex for employers, of course. And we begin, as always, with the provisions of the Labour Relations Act, and more broadly, the Constitution. And employers, as you know, will have entered also in the retail sector into collective agreements with employees and their trade unions, regulating a range of things like rates of pay, hours of work, increases from time to time. And those agreements are documented and reduced to writing, and we call them collective agreements, and they are legally binding under Section 23 of the LRA. And so where an employee or a union on their behalf is a party to a collective agreement that prohibits a strike over the issue in dispute, then under Section 65(1) of the LRA, an employer must look at their collective agreement, determine whether the new demand is in fact an issue which is already dealt with there, and if it is already dealt with there and it says that a strike over that issue in dispute is prohibited, then the employer must draw their attention to that and say, look chaps, you're chancing your arm, terribly sorry, better luck next time. But of course, it's the real world, and collective agreements, it's hard when crafting a collective agreement at a particular time to provide for every single incident that might arise in future. And it might well be that there is a collective agreement in place which does not, properly speaking, regulate the issue in dispute. And so under Section 65(3) of the LRA, if the issue in dispute is regulated by a collective agreement, then they're not allowed to strike. A demand for danger pay, however, in a COVID-19 environment, I'd imagine that there are circumstances where it's not in fact regulated by a collective agreement. And then an employer has to take a view. Is this a genuine demand being made by the employees? Is this a genuine mutual interest demand being made by the employees? And if so, the employer might well then be at risk of staring down a strike. But mercifully, it's not as straightforward an issue, because our law does prize collective agreements. Our law does prize orderly collective bargaining. And I would urge that our clients and that employers generally in the retail sector firstly consider their position, reflect, and then take advice. Because if the issue in dispute, and the courts adopt a rather wide view on this, if the issue in dispute is capable of regulation in an existing collective agreement, then a court will not willy-nilly allow a trade union and its members party to such a collective agreement to resort to power. That, of course, must be counterbalanced against the constitutionally enshrined right to strike. And there are any number of judgments that say that we mustn't read down or inappropriately limit that right to strike. So if, properly speaking, the demand falls outside a documented collective agreement and its purview, then an employer might well be facing a strike. But the first question to determine is whether properly speaking, the true nature of the dispute is one that has been the subject of collective bargaining and is dealt with in a collective agreement.
Yeah, so I mean, it's useful in those circumstances to introduce a clause into your collective agreement that says this covers all the monetary issues and there will be no further monetary demands of any nature whatsoever that will occur coming forward. That,
Quite right. What we often advise is wording to that effect, and then I think it is not any trickery or chicanery. Employers have in the past also inserted peace clauses in their collective agreements that regulate the engagement between the parties for the currency or the life of the collective agreement.
I'm conscious there's one other question to be that is answered, but I'm also conscious we've reached our time limit. So this question I'm going to be dealt with personally with the person who asked it. But if we could just then wrap up. Thank you everybody for joining us. Thank you to the participants who have logged in. Thank you in particular to Siobhan for making your time available. It was incredibly useful. This is as I say, the first part of a two-part seminar. The second part will be on the future of the retail industry and what it's going to look like. And we're going to deal with issues of distribution centers, warehousing, whether that takes you into different sectoral and bargaining councils. But we will cover that in the next one. Thank you everybody for joining us. This will be available on our website as a recorded session as well. Thank you and look forward to seeing you. For the two people who have asked questions, I will endeavor to answer you directly. Thank you very much. Cheers.
Thank you.